Let's go on the record on cause number DC193038. Counsel, make your appearances.
Your Honor, this is Maureen Farrell. I'm here on behalf of the plaintiffs, Diane Crapeau and Laurie Renninger.
Mr. Galini, you need to unmute, sir.
How about now, Your Honor?
We can hear you.
Great. Your Honor, John Galini for the defendants, Michael Combs Property Movements, in this motion for reconsideration today.
And it was a little unclear to me from reading the clerk, what the clerk submitted today. Is it just the motion to reconsider set today, or is there some other motion set today?
I'm only aware of a motion for reconsideration.
Is that right?
Same, Your Honor.
Okay.
Yeah, I filed a response to it. Did the court receive that?
I did. I read all of that, but they also put something, another motion on the docket that I think they put the second motion for continuance on the docket, and I thought that I'd already ruled on it, so I was a little confused. So I think it was a problem with the clerk's office that they, I was kind of confused, but I assumed it was just a reconsideration, but I wasn't sure. So yeah, so let's go ahead and go forward. I've read everything, but you guys can make your oral argument.
Thank you, Your Honor. Your Honor, as we're the movements in this matter, as you are well aware, last month we had a motion or a hearing on the second amended motion for partial summary judgment regarding the cause of action for breach of fiduciary duty. And the court at that time listened to both of us, reviewed their motion, our response, and issued an interlocutory judgment in favor of the plaintiffs on the cause of action for breach of fiduciary duty, and nothing as to damages or anything of that nature. And so I'll spare the court going over that because I think it's fresh enough in everybody's mind this is purely a motion for reconsideration of the court's order on that. It's certainly not an attempt for a do-over as plaintiff's response is stated, and it's brought in the proper court and not in a motion for reconsideration on an interlocutory judgment for a cause of action when there's several causes of actions. This would still be the proper court for that to be brought in, as you have the plenary jurisdiction on this one. The motion for reconsideration is brought for the reason that the movements believe and still believe strongly that respectfully that the court erred in taking the facts and saying that it was proven as to the point of a matter of law as to the elements regarding the breach of fiduciary duty. And Your Honor, I fully admit in the response as well that there is not a whole lot of evidence that we were able to provide, and certainly I did a subpar job in the affirmative defenses being linked to the affidavit. However, even if we had not made a response to the motion for summary judgment, it's well acquainted in Texas case law, as I brought out in arguments and authorities, that the onus is purely, as far as to the matter of facts, upon the plaintiff or the party bringing the motion, plaintiffs in this case, to establish each and every element. Your Honor, the place in which we believe that the court erred in taking that leap from fact to law is the point to where it would take it from a plaintiff being able to conclusively establish it, and to the point that where a reasonable person could not ever differ on the conclusion to be drawn from the evidence. Your Honor, it was the plaintiff's duty to provide the evidence. However, it's the contention of defendants that reasonable people could still look at all of the statements and the evidence and make a differing opinion than plaintiffs are forwarding in their summary judgment. And it is for that reason that we believe that it doesn't go to the level of a matter of law, but stays as a fact question that would be right for a jury rather than right to be found in a motion for summary judgment. And Your Honor, that extends to the duty as well as to the possible breach and to the damages. Your Honor, the references to gifting and other things are not any attempt to put in additional evidence, because we certainly didn't attach any, because that would be outside of the boundaries of the motion for reconsideration. But just for flavor, as to what's been in the petitions, what's already been in the depositions that have been attached, but that the facts relative to the case, basically, even based upon the testimony and the evidence that was provided in the original motions brought by the plaintiffs, lead to differing opinions based upon whoever's looking at, even reasonable people, Your Honor, and that's our contention regarding that. And the burden doesn't shift from them unless they've taken everything to that level to where reasonable people could not differ. And so we did file a response, and that was the attempt of the response, was that there was replete of some things as to duty and also replete as to breach and damages that could not take it to a matter of law, that would leave it ripe for a jury. Cases for breach of fiduciary duties are fact driven. And as in this case, the court needs to consider how reasonable people differ. That it's basically a sister versus a brother. We don't have any other spectators to come in and say the parents are deceased. Everything is going to be an affidavit or a word that's given by either the plaintiff or an affidavit or a word that's given by the defendant or by the defendant. So either way, we can have very differing opinions on every word that's spoken from both of them. We believe, and where the court erred was just in the fact that in reading the plaintiff's amended second motion for summary judgment, where they state as factual that it's undisputed deposition testimony, or that he said certain things, there were no magic words provided or anything that would tell the court, as a matter of law, that there was a fiduciary duty. And we're dealing with an informal one, and I think both parties can agree that if there was a fiduciary duty, we're not talking of the level of a trustee or anything of that nature. These are all informal issuances. But it leaves entirely open for the interpretation of the fact finder, which we requested a jury case in this matter, to determine from all of the testimony given and not just cherry picked phrases as to what relationship, if any, was established. And we believe, Your Honor, respectfully, that the court erred in seeing that there was no origin of the duty that was provided to, as far as I guess the prospective duty that was provided or requested to be provided to the plaintiffs for filing the suit. Whether the duty would have only been to Betty, whether the duty would have only or would have extended on to the siblings, two of which are in the suit, and then the defendant obviously one, and then there's another sister who's not in part of the litigation at all. And so, Your Honor, the evidence is replete. It doesn't exist in their motion or their amended motion as to the origin of the arising duty. And Your Honor, it's for that reason that we requested the court's reconsideration, not based upon the evidence, but based upon the lack of evidence. There's plenty of evidence that's been provided by the plaintiffs that there's a dispute and there's some fact issues, but it doesn't take that inferential leap from fact issue to matter of law. And Your Honor, it's for that reason that we'd ask that the court reconsider and withdraw the previously entered interlocutory order, because it is silent as to the duty or how the origin of the duty would have arisen, because that is important in this case. It's silent if there was a duty or how the duty or who the duty was to, whether or not there was even a breach. And then it's fairly silent as to if there were damages, and the damages are very difficult to prove how they arise without the preceding matters being proven. To what extent, to what dollar, to what account. Without the first elements being proven as a matter of law, you just can't get to the other ones being able to be proved to the level that would take it from a fact question to a matter of law. And Your Honor, for that reason is the reason for our reconsideration, and I pass on that. Thank you.
Response?
Yes, So, Your Honor, when you initially heard this this motion, you would have considered, which we reattached to our response to this motion, all of the summary judgment evidence that we offered in support of our motion for the partial breach of summary judgment. To be clear, we recognize, of course, that it's difficult to win a summary judgment on affirmative claims, right? Even if you're only raising a question of liability. And so that is why we were very careful in our drafting of the original motion to make sure that we were offering evidence and attaching it as required under the rule to satisfy each element of the breach of fiduciary duty claim. Your Honor observed that, said that there was not a response, right? So that Your Honor found, I think, that we had satisfied our prima facie duty and that the burden had shifted and that burden was not met. Nothing has changed from that original hearing. So again, carefully drafted our response to the motion for reconsideration. Rule 166, the court's deadlines for dispositive motions are there for a reason. They're there to limit the issues that are before the parties at trial. And I think what you heard Mr. Galini say respectfully is that they just want to leave it all open, notwithstanding the rules, notwithstanding the desire of the court to limit the issues for the jury when possible through dispositive motion practice, that we should just set all that aside. And even though the defendants have not offered any alternative summary judgment evidence to contradict the summary judgment evidence that we raised in support of all of the elements of the breach of fiduciary duty, that Your Honor should ignore that and ignore the dispositive motion practice that both parties have engaged in, and ignore the rules with respect to dispositive motion practice and the desire of the court to narrow issues for ultimate resolution by the jury. You should ignore all that and just let the jury hear it all anyway. And if that's the case, then why would we have bothered to have done a dispositive motion? And as I said in my response, this motion or some version of it, right, has been on the books for 2 years, right, for 18 months. This is why we do discovery, right? And it's why we engage in this motion practice. And so I don't think anything's changed from the last hearing, Your Honor. And obviously we would ask that the court uphold its June order, I believe June 21st order granting the partial summary judgment. Obviously it's actually a modest grant of an affirmative claim, right? It doesn't make any pretense of resolving all of the issues in the manner, doesn't speak to the amount of damages. I think that we have upheld our burden. The defendants have failed to respond. The court got it right the first time, and the motion to reconsider really doesn't address, doesn't raise a question of law, an error that the court has made that needs to be rectified. With that, Your Honor, I'd ask you just to uphold the order. Thank you.
Based on the record before me, the court will deny the motion for reconsideration. Have you submitted an order yet, Ms. Farrell?
I don't think so, Your Honor.
Can you go ahead and submit an order on that and email it to Mr. Galini for his approval, and then make sure it says on that it was heard on July 30th, 2021. And so at the very beginning, instead of on this date, but on July 30th, 2021.
Okay.
Share it with Mr. Galini. Once he gets back to you with the form of order, then go ahead and e-file it and email it to my court coordinator, Rhonda. Anything else, guys?
No, thank you, Your Honor.
Am I allowed to reply?
Okay. You're allowed to reply. Go ahead.
Well, if you've already ordered it, it would be moved, but I'm just asking to her response.
I'm not trying to keep you if you'd like to say something else.
Okay. Yeah, Your Honor, as far as if this were something of a contract case, I would 100% agree with Ms. Farrell. This is not that type of case. This is a fact-driven case with differing opinions. And Your Honor, once again, respectfully believe, and from the evidence, have to contend it once again for my client to this court, that reasonable people can certainly look at that motion for summary judgment and make differing decisions regarding whether there was a duty and regarding whether there was a breach or even any damages. And Your Honor, the court takes too great of an inferential leap
I haven't ruled on the issue of damages in this case.
Well, I understand that unfortunately, though, they must be able to prove damages to receive the interlocutory motion for summary judgment on this. It is an element of breach of fiduciary duty, Your Honor. We can't ignore it. And I'm respectful, but I'm passionate only because this
Mr. Glaney, I respect your opinion, and based on the record before me, I think I have no choice but to grant the summary judgment. I don't know what else to say other than that. But just get me an order on this, and you guys have a good weekend. And I don't want you to change this, Ms. Farrell. I have not ruled on the issue of damages. That's something
Of course not.
for the jury to decide.
Of course
All right,
not.
guys, you guys